Good evening, everyone. I'm Geraldine Velasco from City University of Pasay School of Law, and tonight I'll discuss to you particular topics on local government law. First of these topics is the corporate powers vested to local government units. It is provided under Section 22 of the Local Government Code because local government units has dual character, the public and the private. So these corporate powers are provided in Section 22 of the Local Government Code, which states that a local government unit has corporate powers, one of which is to have a continuous succession under its corporate name. So if, in short, even if there is a change in administration, the corporate name remains. Second power is the corporate power to sue and be sued. So although there is a doctrine called state immunity, wherein the state cannot be sued without its consent. However, consent is either express or implied. In the case of local government unit, it is actually a express consent since it is provided under Section 22 of their very own charter, which is Local Government Code of 1991. Additionally, the local government unit has the power to have and use corporate seal. So we have that one here also in Pasay. You can just have and search it. Next power is to acquire and convey real and personal property. There are two types of property: the properties of public dominion and the patrimonial properties. Public properties of public dominions are those that are for public use, public service, or for the development of national wealth. These properties are beyond the reach of local government unit, meaning they cannot convey it, encumber it, lease it, because they only hold these properties in trust in favor of the state. However, patrimonial properties are those acquired by local government units under its private capacity. These patrimonial properties are those not for public use or public service or for development of national wealth. Local government unit may sell it, encumber it, use it in a way they see it fit. However, if they transfer it or sell it, it must be through public bidding. Next power of local government unit is to enter into contracts. Of course, local government units are mandated to fulfill their obligations for the benefits of their constituents. So they must enter into contracts. They must have powers to enter to contracts for programs and projects that will benefit their constituents. And these contracts, if it's duly executed, as well as it's perfected or it's valid and it's valid and binding, it is constitutionally protected. Before, however, the local chief executive can enter into contracts, the authorization from the sanggunian must first be had. This is a necessary requirement. There is an instance, however, that this requirement is no longer required, the authorization from the sanggunian, if the said programs or projects wherein the contracts relate to are already identified or detailed out or specified in the appropriation ordinance on the same year. So the authorization from the sanggunian is no longer needed. And the last power is to exercise such other powers as are granted to corporations, subject to the limitations provided in this code. So we have here the case of Sangguniang Panglalawigan of Bataan versus Congressman Enrique T. Garcia. In this case, Congressman Garcia authored Republic Act 8562. And this law provides that the two state-run colleges in the province of Bataan will be converted into Bataan Polytechnic State College. And in doing so, the titles to this land must be transferred to Bataan Polytechnic State College. However, the petitioner, the Sanggunian, argued that these properties, the lands where the two state colleges are situated, are patrimonial properties of the province, so they cannot be taken away by the national government without due process or just compensation. So that's the main issue here, whether the subject lands are patrimonial property. In this case, the court ruled that it is not a patrimonial property of the province of Bataan, because it is a property of public dominion, because it's the purpose of such property is for public education. And so, even though that properties are under the name of the province of Bataan, unless the province proves that the funds used to acquire said property is actually the funds of the corporate funds of the local government unit, then it is only presumed that the said properties are only held by the province of Bataan in trust in favor of the state. Our next topic is about ultra vires acts performed by local government units. Ultra vires acts are those acts that are beyond the scope of authority granted to local government units. There are two types of ultra vires acts, the primary and the secondary. The primary refers to acts that are performed entirely beyond the powers vested or entirely beyond the authority vested to local government units. Any contracts that performed beyond the scope of authority of the local government units are void. So any acts performed are void. The second is the secondary ultra vires acts. These are acts performed still within the scope of authority of the local government unit. However, there are irregularities or defects in the performance, and there needs to be ratification in order to validate the said performance acts or contract. We have the case of Meralco versus City of Muntinlupa. In this case, Meralco was assessed for franchise taxes under or pursuant to Municipal Ordinance 9335. However, the City of Muntinlupa issued this ordinance while it was still a municipality. Although it has already been converted into a highly urbanized city, Meralco argued that that did not cure the defect on the said municipal ordinance. So the main issue in this case is that whether or not the city of municipality, prior to its conversion, has the power to levy franchise taxes. So the court ruled in the negative and stated that the said ordinance is actually null and void for being an ultra vires act. This is because under the local government code, municipality may only levy taxes that are not levied by provinces. And it is stated under Section 137 of the Local Government Code that provinces has the power to levy franchise taxes. Thus, the municipality is precluded to levy franchise taxes. So, the said ordinance was declared null and void for being an ultra vires act of the local government unit. Lastly, for our topic tonight, we have the liability of local government units. Of course, local government units, as stated earlier, can sue and be sued. So, they can be held liable for the performance of their functions. But, let's first distinguish suability apart from liability. Suability refers to the state's consent to be sued. This is expressly given in Section 22 of the Local Government Code. Liability, however, pertains to the applicable law and established facts of the case. So that would depend on the evidences shown in a proceedings. But when the state waives its sovereign immunity, as in the case of local government unit, generally if they are performing their governmental functions, they cannot be held liable. But, of course, they cannot be held liable if there's no bad faith because of the presumption of regularity. But if they are acting under their proprietary capacity or they are performing functions of in proprietary nature, they may be held liable. So, local government units may be held liable under contracts as well. Of course, contracts entered into by local government units are constitutionally protected. So, under the doctrine of implied municipal liability, even though there is no express contract, only under an implied contract, local government units are obligated to pay the reasonable value that was received or appropriated by them for the benefit of the local government unit. And the doctrine of estoppel does not apply to void contracts because void contracts do not give rise to legal effects. So, and besides, if the contract is void, it probably is beyond the scope of authority of the local government unit to contract from the beginning. So they cannot do things indirectly which is prohibited by them to be done directly. Local government units may also be held liable under torts. There are several provisions in the Civil Code that may be used to hold local government units liable, such as when the state acts through its special agents, or when there are defects in roads or manholes, provided, of course, they have control and supervision thereof. And if the local government unit is or may be held subsidiary liable uh, with police peace officers if they fail to render aid or protection to their constituents. So our last case is the Municipality of San Juan versus the Honorable Court of Appeals. In this case, private respondent Laura Biglang Araw, while she was riding in her car 10 p.m. at night while it was raining on the National Road of San Juan City, the left front wheel of her car fell in an open manhole. So, in the investigation, the police officer who was there in the incident stated that there were no barriers to cover the said manhole or to alarm people that there is an open manhole there. So then Laura sued the local government unit of San Juan for damages that she sustained. So the issue here is whether or not the local government unit may be held liable for the damages sustained by the private respondent. And in this case, the court ruled in the affirmative. Under Article 2189 of the Civil Code, the court stated that ownership of the said land or the said road does not actually matter so long as the local government unit has control or supervision over such road. And in this case, it was established that the San Juan City or the municipality of San Juan actually has control and supervision of the said road because they are doing an excavation process in that road. So that would be all for our topic tonight. And thank you very much for listening again. I'm Geraldine Velasco from City University of School of Law. And thank you.